So welcome again to this discussion. We shall be passing through 2011 exam, and in case you didn't listen to our 2010 analysis, then basically you can check it, and then you also listen to it, because we analyzed the 2010 exam. We are now analyzing the 2011 exam. So pass the bar pre-entry answers, pass the bar your legal mentorship hub. This is another time to remind you that we offer mentorship to LDC students. We also train for pre-law LDC for pre-LDC exams, and also for masters. And in case you want to do masters at Makerere University, we also have a pre-masters training. We do all kind of consultations in law, including legal presentations, and also consultations in law. Offer those services, and in case you have any dissertation or maybe research proposals in law, then also do those kind of work. We are basically a team of 5 advocates committed to making you pass the bar. So for those of you who will be admitted to LDC and you would like to continue with us, we have a subscription, which is basically an online mentorship program, which basically means that we cover all campuses, Mbarara, Lila, Mbare, Kampala, as well as all the 4 campuses are covered, because we always have online discussions in the weekend, and also we give notes on all the workshop. So it helps you make the journey easier, and you pass with confidence. So after being admitted, you can hit us up, and then if you can afford the subscription, you can be part of our mentorship program. So 2020 we have legal methods. What is the relevance of website www? I believe we all understand that, where we always get cases online. Explain the meaning of applied law. Applied law section 1 and 50 of the Judicial Act refers to the laws of the United Kingdom, acts that are recognized and enforced in Uganda by virtue of constitutional or statutory provision. So section 1 and 52 of the Judicial Act defines applied law to mean the United Kingdom acts that are enforced in Uganda. Of what relevance to Uganda was the Judicial Committee of the Privy Council until 1964-7. Until 1967, the Judicial Committee of the Privy Council UK served as the final appellate court for Uganda. Is a 1974 decision of the Court of Appeal for East African binding in the High Court of Uganda? Give a reason for your answer. No, it's not binding. Article 1229 sub Article 2 of the Constitution provides for courts of record, and it's not one of them. So it's just persuasive. 5, in some law reports, you will find the statement the House took time for consideration. Sometimes the Latin abbreviation "chu advervalt" is used. What's the meaning? "Chu advervalt" means the court wishes to consider the matter. It indicates that the court has reserved judgment and will deliver a decision at a later date after due consideration. 6, which theory of law best explains the basis of the offense of being idle and disorderly? Give a reason for your answer. The positive theory of law best explains it. According to legal positivism, e.g. John Austin, law derives validity from being enacted by a recognized sovereign authority, not from its moral worthiness. In legal terms, the preparation of the 2000 edition of the Laws of Uganda consists of basically revision. When we talk about revision, this involves consolidating, renumbering, and revisiting existing statutes without altering substantive law. For example, what has happened with the 2024 laws, revised laws. Which of the following expression is correct? 1A, 2 council, state attorney. So 2 council. How can an international convention become law in Uganda? By ratification. Article 127 of the Constitution. Who is the head of the Uganda Bar? The Attorney General under Article 119 of the Constitution. Then constitutional law, what is illegal? This was referred to as the Legislative Council, was the colonial legislative body established in Uganda in 1921 by the British. Explain the meaning of abrogation of the Constitution. Abrogation means the total overthrow or repeal of a constitution, usually through a coup or extralegal means. That's what we call abrogation. 13. Comment on the proposal for the Parliament of Uganda to declare National Day of prayer for the national state. Under Article 7, we understand that Uganda is a secular state, which means we will not adopt a state religion. 14. What is the consequence if a member of Parliament who was elected on a party ticket becomes an independent? Article 83, sub Article 1G. An MP loses their seat if they leave the political party on which ticket they were elected to join another or become independent. Under the Constitution of Uganda, a new district is created by Article 179, sub Article 1. New districts are created by parliament resolution, not by presidential order or ministerial statement. 16. State one option available to the president if he is opposed to a bill which has been passed by parliament. Under Article 91, 3B, he can fail to assent to it, which be returned to parliament. State any decided constitutional case from Uganda or any country in the Commonwealth. Have Uganda vs. Ex parte Matovu, Anthony General vs. Tinyefuza. 18. Nanyuzu was arrested at 7 a.m. and charged in count at 9 with abuse of office, prostitution. Did Nanguz get a fair hearing? No, Nanguz did not get a fair hearing. And Article 28, every accused person has the right to a fair and public hearing. State at least one resource under Chapter 15 of the Constitution, which the government holds in trust. Under 2372, we have forest reserves, game reserves, national parks, rivers, lakes, and wetlands. 20. The amendment of the 1995 Uganda Constitution can be affected by 1. An act of parliament from Article 259 to 263 of the Constitution. Then Section 0 of contracts. The Contracts Act Cap 284 has codified the law of contract. State 1. Advantage or disadvantage of such codification. Advantage: codification provides clarity and certainty by consolidating common law principles into a single statute. Disadvantage: codification may limit flexibility because it may freeze the law and execute useful and exclude useful evolving common law principles. So basically, codification is where all the law is written down in one act. 21. State one exception to the general rule in penal cause case. General rule was part payment of a debt is not satisfaction of the whole, except part payment before the due date in a different place or by giving a chattel may discharge the debt. Then also we have 22. If a person makes a written pledge to contribute money towards a friend's wedding, is that agreement enforceable? No, under Section 9, there was no intention to be legally binding. 23. A motorist asked a group attendant of a fuel station to fill his tank with petrol. The attendant instead filled it with diesel. Advised the motorist. Basically, have Section 60. Party in breach must compensate for loss accused, but also have the case of Dr. Vincent versus Total Uganda, where his Range Rover was filled by petrol instead of diesel, and he was awarded damages. Then what is a simple contract? The simple contract is the one which is either oral but not written, and it's always below 500,000. State one factor considered in determining whether goods contracted by an infant are necessaries. Nash versus Innerman, they are basic needs, or maybe they are important for the minor for the basic needs. Define innocent misrepresentation. Section 1 of the Contracts Act Cap to 8. Innocent misrepresentation, a false statement of fact made honesty without intent to deceive. 27. Briefly explain the contra profrentum rule. You can see the case of Houghton versus Trafalgar Insurance Company, where a contract term is ambitious. It is interpreted against the party who drafted 06 to rely on it. 29. Pengo received a job from Maribu and accepted it. Maribu withdrew the offer after 2 days. Mapengo sued for breach. Since then, she spends all her time at home reading novels. Comment on the likely consequence on her conduct. Mapengo is entitled to damages for breach, however they can be mitigated because of his conduct. Section 30, Malala was booked to sing at a contract but cancelled due to cholera outbreak. Is there a breach? Basically, there was no breach because under Section 65, the contract was contract discharged where performance becomes impossible or unlawful, and you can see the case of Taylor versus Cradwell. Section D of torts. Name one consideration for determining whether a person can bring an action for breach of statutory duty. Consideration 1, whether the statute was intended to confer a private right of an action on an individual. We have the case of Kane versus Smith. What do you understand by the term standard of care? The degree of care and skill a reasonable person is expected to exercise in particular circumstances to avoid foreseeable harm. Look at the Donegal versus Stevenson. Then we have Mr. Swagger, an unemployed graduate, was knocked down by a car on his way to a job interview, admitted to hospital for 2 days and missed the interview. Can he recover damages for the salary he would have earned? No. And you can see the case of Hardy versus Baxendal. Only foreseeable losses and actual damage are compensated. Plato bought a retired elderly police dog for his children as a home pet. Recently, the dog beat a passerby. Advised Plato about his liability. I have the Sayanta rule. You can see the Fowler versus Learning, that one is expensive for any damage caused by his animal. Then from there we have we can proceed to 36. Kauna bought a plot of land near municipal rubbish dumping site. He built his home and complains about unbearable smell. This is basically a nuisance. And we have the case of Dr. Canyeres versus the Trust Board of Rubaga Girls. But also remember, under Sturgis versus Bridgman, interference must be substantial and unreasonable, and coming to a nuisance is not a defense. 37, it is said that trespass land is a continuing tort. What does that mean? You can see the case of Justin Alutaya versus Starring Civil Engineering Company on trespass. Continuous tort means each unauthorized intrusion on land is a separate action wrong. So if someone leaves an object on your land, the trespass continues until removed. 38, during a quarrel, Charlie pointed a toy gun at a court and said, if this was a real gun, I would have shot you. Advise a court whether a tort was committed. No assault was committed because in Arab versus Ireland, the threat was taken away by saying that it was a tort, by saying it was a toy. 39, in your own words, explain what you understand by occupier's liability. Occupier's liability basically is a duty by a person on control of premises to ensure that visitors are reasonably safe from harm. See the case of Fit versus Lancon. Who is a tortfeasor? A tortfeasor is a person who commits a tort. That is someone who breaches a legal duty causing harm to another. Then also we have civil procedure. How can a club which is unincorporated be sued? An incorporated club cannot sue or be sued in own name. It can only act through its members. For example, see the case of Williams versus Natural Life Harris Foods Limited. 42, the plaintiff sued the defendant for trespass, seeking an eviction order. The defendant did not file a defense. There is an affidavit of service on record. What steps should the plaintiff take? Plaintiff should apply for default judgment under Order 9 Rule 20. Order 9 Rule 20. Olympia filed a suit but was absent on the hearing date due to a trial strike. The magistrate dismissed the suit for want of prosecution. Under Order 7 Rule 5, it can be reinstated. Then a magistrate grade 1 has dismissed the defendant's application to amend his defense. The defendant is satisfied best course of action. You can appeal under Order 6 Rule 30. Appeal to the High Court. Define misgender of causes of action. Order 7 Rule 1E. Misgender occurs where two or more causes of action are improperly joined in one suit. 46, an application for an interim order pleaded that if the application was not granted, the main suit would be rendered nugatory. What does this mean? and rendered nugatory means that if the interim relief is not granted, the main suit may be ineffective or fertile. Looks at the case of Sauna Cosmetics versus Commissioner General of URA. 47, an American company with no assets in Uganda, has sued your client. You apply for security of costs under Order 26 Rule 1. What is a compromise suit under Order 13? Compromise means the settlement of a dispute by agreements between the parties. Define taxation of a bill of costs. Under the Advocates Formulation on Taxation of Costs Regulations, taxation is the examination of and assessment of legal costs by a court or officer to determine reasonableness and proper amount payable. 50, plaintiff filed an application by motion instead of summons under Article 126(2)(e), and the case of Hack Bonera versus Francis Bwenje. Francis Bwenje versus Hack Bonera is not defective. Section F, law of evidence. In land dispute, the plaintiff called 10 witnesses, the defense called only 1. Section 133, there is no particular number of witnesses required to prove a given fact. By which of the following is admissibility of evidence determined? Answer is D. None of the above. Admissibility is determined by legal rules, statutes of case law, and not procedural steps like hearings or scheduling conferences. 53, in order to be admitted, it must be shown to be authentic, and the person filing it must be able to show the chain of custody from the original creator or place of recovery, namely the type of which it applies. Electronic evidence, see the case of Jim West vs. Anthony General. What is an exhibit? An exhibit is any document, object, or material produced in court to support a party's case. Look at the exhibit management directions. Then 55, a nurse comes home and tells his wife, "I'm worried for my health. This morning I attended the patient who had Ebola symptoms. Later he dies. Wife seeks proof of occupational disease." Outline a reason to admit the evidence. This is a statement made by the deceased person concerning his own wealth. So under section 30, it can be admitted as a dying declaration. 56, if has been charged with theft of fruits, husband Adam has offered to testify for the prosecution. State your opinion. He's a competent but non-comparable witness under section 120. 58, the magistrate is conducting a voir dire to determine whether a child should testify. Which questions are going to be asked? Ask the child if he knows the difference between the truth and the oath, section 117 of the Evidence Act. 58, Dan sues Sarah of a contract. Dan offers a photocopy of the original. Sarah objects, claiming it's inaccurate. Dan testifies he made it from the original. Should it be admitted? Yes. Section 68, documents must be proved by primary evidence, except section 64, original is in possession to whom the document is sought to be proved. 59, at Mufere's criminal trial for forgery, police officer testified that handwriting appears to belong to Mufere. So section 45, yes, familiarity with handwriting qualifies an opinion as regards that handwriting. 60, Jude law student was charged with stealing liquor. As part of his evidence, he asked the magistrate to take judicial notice that 40 hours reading at law school. Section 55 provides the facts which a judicial notice need not be proved, and section 56 gives examples of judicial notice circumstances. So this one is not among therein. Section G, criminal law, state at least one policy reasons behind the principle of legality. Article 28(7) Constitution provides individuals from a retroactive criminal laws. No one can be convicted of a crime unless it's clearly defined. Which of the following offenses does not require proof of specific intent? We have arson. Then we have the next one. 64, which of the following defenses is limited only to a specific offense and is not a general defense? Voluntary intoxication. Then also the next question is 65, in which of the following situations will the first person named not be imprisoned for the resultant death? B, wife hides in secret. Then mauled by hyena. In which situation will necessary ability not arise? The wife knowing an unexpected outcome arising from the assistance given. Then 67, half a dozen young men, while herding their cattle, met and fought a group of other young men, and one died. Then prostitution must prove common intention. This was probable consequence. Prostitution must prove common intention. The death was probable consequence. You can see that Uganda versus Uganda. What has to be proved before the entire group may be treated as comprises common intention and probable consequence. 68, X desires to burn down offices. At what stage is it an attempt? Answer C, he powers kerosene over the newspaper and lights it up with a match, because those are the ingredients of the offense. 69, at the elements of offense of burglary. Look at section 275 of the Penal Code Act. One will have breaking, entry, building, and intent to commit a felony. 70, Gita and Tendo have a history of not getting along. As Gita was walking along the stairs on their 10th floor of a building in Kampala, he met Tendo, and walking in the opposite direction after an exchange of insults. So no force used pushing 10th floor. So basically the force was unreasonable under section 15. You can see the case of Uganda versus Rwabugenda. Section H, criminal procedure 71. Which of the following terms does not relate to proceeding that takes place before the commencement of a criminal trial? We have case to answer. 72, which of the following takes place at the preliminary hearing? B, determining whether or not there are no reasonable grounds to believe that accused committed the offense. 73, a convict is sentenced to 2 years in prison, but the entire sentence is suspended and the offender is allowed to live in the community under court. The conviction is said to be on probation. Which of the following standard of proof is not required in any criminal trial? Preponderance of evidence. 75, for which categories of offense will an advocate be appointed and assigned to defend an accused person who cannot afford one? We have capital offenses under Article 28(3) of the Constitution. When an accused does not have to post any bail but promises to appear in court, he or she is. And secured bail requires no upfront payment. That the accused signs a written promise to appear in court. 77, after being acquitted of the offense of murder on account of the court having not found a case to answer, an accused person was military arrested and charged with the offense of manslaughter. Explain why this may be improper. This may constitute double jeopardy prohibited under Article 28(3) of the Constitution. 78, a suspect is accused of having robbed 3 different motorists. To explain whether or not those offenses can be joined on one charge. The offenses cannot be joined on one indictment because they occur at a different time and places and are distinct offenses. Which of the following is not a mode of commencing a criminal prosecution? We said charge and issue, warrant of arrest. Explanation: prosecution typically begins by charge and caution. Criminal summons, complaint on oath or arrest and charge. Charging plus warranty is a procedure for apprehension, not commencement. 81 person is charged with treason and another with defilement of a 17-year-old girl. Each makes an application for bail. Explain how different these applications are. Under section 14 and 15 of the Trial and Indictments Act, in capital offenses you must prove exceptional circumstances, and these exceptional circumstances include old age, certificate with no objection from DPP, and also a grave illness. So that was it. We got aptitude. When basically you are answering this aptitude, you have to make sure that you read. So basically it's like passage reading or comprehension, or maybe what we looked at as passage reading. So don't please apply the law in this section. But if I can read question 8.1, which of the following is accurate in respect to the above extract? The correct answer is D. The impugned decision of the Council of Legal Education was intra vires. Then 82. 82 we are having argument about admin contributions. Correct answer is C. Some admin contribute to law school because they enjoy seeing its smooth court team win. So basically you get these things from the passage. When you're reading, that's where you get those things. Then 84 was a simple math, which was very simple also. This math is logical, don't fear them. Question 85, the answer is B, and it's also goes from reading the passage. So basically how you read the passage and then you come to the right conclusion. Section G, what specific pro-Uganda provision would you like to be included in legislation and policies governing the exploitation, production and sale of petroleum in Uganda? So basically you have to argue this one, of course, with your opinions and ideas, but also try to support it by the law. For example, here we're talking about ownership by state on behalf of the people, Article 244 of the Constitution. We are talking about revenue management and transparency and the Public Finance Management Act, local content requirements by employing citizens, environmental friendly and sustainable development, Article 39, Parliament oversight and accountability, Article 79, and also equitable distribution of petroleum revenues under Article 32, basically affirmative action and providing for marginalized groups. So basically you have to apply the law, don't just proceed as a social scientist. Look at how basically can you connect your discussion to the law. Then 87, ISCO values are natural in the family. They cannot be taught in law school. Do you agree? Outline reasons for your opinion. Basically here we relied on one, family is the foundation of ethics. You can look at Article 31, Article 1 of the Constitution. Need for professional ethics training in law school. Look at the Advocates Professional Conducts and Regulations and also the Advocates Act Cap 267. Legal ethics protect the public and the profession. Look at the case of Uganda Law Society vs. Anthony General. And also law schools and LDC have statutory mandate. Look at Waga versus LDC and Birondo versus LDC. So basically the essence here is to understand what the question is asking you and then connecting it basically to the what, to the laws or cases you might be knowing. So this is another time to remind you about the Pass the Bar Mentorship Hub. Basically for LDC students, we have a mentorship program where students pay monthly subscription. Our program is online and we give summarized notes, and also we prepare you to be equipped for the oral exams and IAs and MOOTs from day one. So for those of you who will be admitted to LDC, irrespective of the campus you are, it could be Lira, it could be Mbare, Mbarara, and also Kampala, we have an online discussion platform where we always discuss in the weekend and midweek. We give you all the notes you require at LDC. It's basically at 100,000 per month. Students pay 100,000 per month, and it's an ongoing process. So if you can afford to meet that budget, if it doesn't constrain your budget, then you are welcome to a discussion group, and we are willing to mentor you at your LDC journey, basically making it easier for you and simplifying the complicated. So basically we remain the Pass the Bar team. In case you want to be mentored for the pre-LDC entry exams, you can also hit me the number on 075 6767284. 075 6767284. Please try to WhatsApp. We shall get back to you immediately, because sometimes we could be in a court and we don't have to pick calls, but for the WhatsApp we always reply immediately. So please have a blessed day.